Thinking about joining Creative Collective? Here are some of the benefits we offer our business members: technical assistance, small business support, and consultations. Enhanced directory listing on Creative North Shore and Creative Collective. Social media marketing for your business through our social channels. Event listings on the Creative North Shore website inputted by our team. Meet the member introductory feature on our websites and social media channels. Free monthly meetups and team building engagements. Business-to-business referral program. Exclusive discounts and promotions from fellow members. Send us an inquiry today at www.creativecollectivema.com/join.
Good evening, everyone. Welcome to our first winter webinar with Creative Collective. My name is Ariel. I'm the Director of Operations here at Creative Collective, and we are so delighted to have each and every one of you here with us live tonight. If you have missed the live, we are going to have this available for our members afterwards. So don't worry, if you miss anything, you can always go back and watch it later. So what is Creative Collective? For those of you who are joining us for the very first time. We are a group of economic development strategists, small business supporters, activation specialists, and believers in the importance of the creative workforce. We foster growth, sustainability, and scalability for small businesses, creative thinkers, organizations, entrepreneurs, pretty much anyone you can think of who has a creative bent. We are here for you. We are going to put up our Q&A as well, so if you have any questions as we go, we would be delighted to take those questions. Now, tonight, we have a very, very special presentation for you. We have Jess Manganello with us from New Leaf Legal, a boutique law firm that specializes in business and intellectual property law services for startups, small businesses, entrepreneurs, and of course, creatives. From corporations to solo ventures, we help businesses with their daily legal needs, often functioning as outside in-house counsel. So I'm going to bring Jess on board with us here today, and she is going to teach you all about the basics of what you probably should have learned in school as a creative on the law side.
Sorry about that. All right. So I'm saying thank you so much for having me. I'm bringing up the slides right now. I'm going to get a screen share going so everyone can see it. And as we go along, feel free to ask questions. Happy to answer those. I'll also just give a bit of a warning. And that I tend to get really excited about this topic. I say a lot about it. I get a little ahead of the slides. And I also have 5 animals, so you're bound to see cats or hear dogs at some point as we go along. So bear with me. All right. Are you able to see the screen? Good to go? Okay. Let's see. Try again. All right. Great. All right. Let's start the slideshow. Okay. All right. So just to get us started, the basic reasons that you're going to form an entity. Actually, I should go back. One of the first things you should do when you're engaging in any sort of business is to form an entity. We're going to talk about why, and we're going to talk about the consequences of not having an entity and kind of what you have to deal with there. And even if you're in a creative industry, It's important to think of it as a business and to protect yourself and to protect your intellectual property, and an entity is a big part of doing that. So some of the basic reasons you're going to do that are liability protection, tax reasons. There are tax deductions you have as a company that you don't have as an individual, but also to make sure that whatever you build can continue on without you or into the future. The types of entities we're going to cover are things like sole proprietorship, partnership, corporation, LLC, and then I'll cover social enterprise a little as well. All right. So sole proprietorship is the most common because it happens by default. So if you decide you're going to engage in business and you go out there and you market it or you put something up for sale, you are now a sole proprietorship. When you're a sole proprietorship, it's just you. You and your business are the same. There aren't any formalities. There's nothing you have to do or file. It's just by default under the law, that's what you are. It means you have sole control and decision-making over your business. It's completely, enmeshed with you as a person. It is just you operating. So there's no separate taxes, no separate filings. All of your income and all of your deductions just go through you as an individual on your personal return. On the flip side of that, though, it means you have unlimited personal liability. And what I hear a lot from people, especially when they're just starting out, if they just graduated from school, if they're just going through some life transitions, is I don't have anything. Haha, go ahead and sue me. The problem, though, is that if someone does sue you and they win, they have 20 years to collect. So for 20 years, they can garnish your wages, put liens on your property, get access to your tax refunds, all sorts of things that they can do until they get full satisfaction of their judgment. And while you might not have much now, 20 years is a long time to have that hanging over your head. It affects you, it affects future businesses, it affects partners, inheritances, your children. So it's really a good idea to think about limiting that liability as much as you can when you go into a business so that you avoid having that consequence. Another downside of a sole proprietorship is that because it's just you. So if you were to die, that's it, business over. You would have to arrange in your estate planning for how any assets you have associated with the business were to transfer on, but it's not like someone can just step in and take over your business and run it. You'd have to wait for a court to appoint the executor of your estate, which can take years sometimes. And only then would they be able to step in and do anything, which would really just be to dispense of your assets to your beneficiaries. So if you die, business is over. It's also really difficult to transfer ownership of a sole proprietorship. Unless you have very defined assets that you can sell, you can't, it's really difficult to transfer goodwill when you're a sole proprietorship and it's just you and your name. It's really difficult to transfer customers. So depending on how established you are, there might be ways to do it, but generally it's just a lot more difficult. Let's see. One thing you do want to consider if you're a sole proprietorship is that if you use a name other than your own, so if I was doing business as New Leaf Legal but without an entity, I am supposed to go to my city or town and file what's called a DBA. It's usually around $50, lasts for 3 years. Most towns you still have to go in person, but you file that, register with your town to say I'm an individual doing business as a trade name. So that is the one filing that you might have to file if you're a sole proprietorship. The next one up is a general partnership. This is also something that just happens by default. And so that's if there's more than one person doing business. And here's where I usually like to give a warning. People use the term partner and partnership very casually, but it actually has legal meaning. So what I tell any business owner, any entrepreneur, any creative, just take that word right out of your vocabulary. Unless you genuinely want a partnership, don't use that word. And the reason I say that is because you might be considering planning an event or organizing a one-off thing with someone. And you say, we're partnering on this. And you say it to a third party. It goes into an email. Oh, this is my partner on this. Or maybe you're considering actually working with them long-term, maybe bringing them in and jointly running the business together, but you're still just feeling things out. It's not definite yet. And now you've made a representation that there's, oh, I partnered with you. The issue is that if that relationship doesn't continue, if it breaks up for any reason, they can come back and use that as evidence that you were actually in a legal partnership. And when you're in a partnership, it is joint control, joint ownership, joint rights to everything. And it's based on how many people are in the partnership. So if there are two of you, it is 50-50 across the board. So you really don't want to use that word unless you mean it, because there are lawsuits, so many lawsuits every year with people claiming ownership and claiming rights to intellectual property and equity and money and control just based on the fact that someone used the word partner a few times. So don't use the word partner unless you actually want a partner. Now, if you are actually working together, forming a business together and operating a business together as partners, you want to know that, yes, again, here's a situation where there are a few formalities. You don't have to file anything. You don't have to put anything with any state or city other than maybe a DBA. It just happens by default when two or more people are entering into a business relationship. It also means that, like I said, depending on how many people are in the business, equity, control, rights to the assets of the company, everything is just split equally among the partners. And that happens by default. So even if you put in all of the money and put in all of the intellectual property and they come in to provide services, whether or not they provide those services, they still have equal ownership to you to everything you brought to the partnership. Another thing with partnerships to be aware of is that when you were in a partnership, one partner can bind and make liability for every other partner. So if a partner signs a lease for 5 years, $300,000, and they never asked you, or they did, and you said no, you are liable for that lease. And partners are jointly and severally liable, which means it's not, well, we own 50-50, we're only 50-50 liable for this. No. Each partner is 100% liable until whoever the creditor is gets their money. So if you're the one who has assets or money or that W-2 job where they can garnish wages, you're the one who's going to pay. And you might end up paying more than them and vice versa. So another thing to really be careful about when you enter into a partnership. Partnership, like sole proprietorship, is a pass-through. Although a partnership actually has to file a separate return. It's a partnership return. And then each partner is issued a K-1 that goes on their personal return, kind of like a W-2. So all profit and loss of the partnership get taxed at the personal level. You can mitigate some of all of this with what's called a partnership agreement. Those are usually very comprehensive, very expensive to draft. They have their downsides as well. And I usually don't recommend them because you can form an entity and deal with a lot of this using an entity in a way that's much easier, much cheaper, and much more effective. Other issues to be concerned about with a partnership are that just like a sole proprietorship, ownership is not easily transferable. So under default partnership statutes, if one of the owners leaves, partnership over, you have to liquidate and dissolve. If one of the ownership dies, partnership over, liquidate and dissolve. You have to have a partnership agreement to establish that the partnership can continue on and what the rules of that are and whether or not you can sell it or transfer it. So that partnership agreement ends up being pretty robust. Other than that, you can have the partnership agreement, file a DBA if you're using a trade name other than your own. I do suggest, even with a sole proprietorship, but definitely with a partnership, getting an EIN. So an EIN is a tax number that's given from the IRS. It basically functions as the social security number of the business. It's a really good thing to have because it means you're not using your social security number everywhere. And especially in a partnership, you don't necessarily want everything on just your credit report. So it really helps the company in terms of keeping things separate for tax purposes, but also as you go along, you can start building a business or a credit score for the business and get that business credit history up, which is important so we'll talk about a little later on. Also with the partnership, you want to keep separate books and records. So now that you're a partnership and you have someone else that you're answering to, it becomes really important to keep all of the finances separate. Set up a separate bank account, have separate credit cards, have separate books. You want to make sure that all of the partners can see that no one has been taking money that they shouldn't have or buying things that they shouldn't have. Because now you have some innate duties to one another. Okay. All right. So the next one, and actually, are there any questions before I move on? No. Okay. So the next entity is the corporation. Everyone's heard of this. You've probably heard, C Corp and S Corp thrown around. They're actually the exact same thing. It's just one has a different tax election. A corporation is the longest standing entity under law, and it is very regulated. So lawyers refer to corporations as a creature of statute. And that's because everything about corporations is embodied by statute. There are a lot of things that are just built in that you do and have to have. It is a completely separate legal person under the law. So it's completely separate from you. It can operate on its own. It can own itself. The owners of the company are called the shareholders. Then you have directors and officers. Directors have control of the company. They have fiduciary duties to the shareholders, and they determine who the officers are. The reason the corporation is so popular is, besides its longstanding nature, is that it has limited liability for its shareholders. So when you own a share of a corporation, and that corporation, goes into bankruptcy and has debts worth millions, the most you lose is that share. You as a shareholder have no personal liability for what that corporation does and what debts it has. So unlike that sole proprietorship and partnership where you're personally liable and on the hook, in a corporation, shareholders aren't liable. They also get the benefit of knowing that directors do have fiduciary duties to them. And a fiduciary duty is personal liability. So if you're the director of a corporation, you are personally liable to the shareholders for making sure that you're doing what you're supposed to do as a director. So in a for-profit, that's maximizing shareholder value. Running the company in accordance with the laws, making reasonable choices so that the company doesn't incur huge debts and go bankrupt. Trying to maintain that shareholder value. Corporations, unlike the partnership and the sole proprietorship, are very stable. So if a shareholder dies, makes no difference. If a director dies, makes no difference. A corporation can exist on its own. It can own itself. It's very easy to just sell shares, take shares back, move things around, and the company is its own legal person, which is great. Of course, being so long-standing and subject to all of these statutes, there are a lot of formalities tied to being a corporation. So I have it? No, I don't. All right, I'll go back. So when you're a corporation, you have to have bylaws. You have to have a stock ledger. You have to have stock certificates. You have to have a corporate seal. You have to have annual meetings of the shareholders and the directors, and you have to send notice to everyone that you're having these meetings. The meetings you have to give notice not less than 10 days before, not more than 60 days before. You have to have all these things in writing to show that you actually did them and send them by mail unless someone is consented to an electronic copy. There's a lot of particular things you have to follow. So if you're running a corporation, you want to make sure you're very detail oriented. You can create templates and things that help. You can have waivers of notice. You can establish, timelines. That's all fine. It becomes easier once you're used to it, but you definitely have to follow up with these things and do all these things and do them on time. The reason being that if you do not follow the statute and if you do not fulfill all these requirements, you lose that liability shield. So the shareholders become liable. And it's called, intermingling. In court, they can pierce the corporate veil. Lawyers are very witty and creative. They can pierce the corporate veil and go after the shareholders because you didn't follow all of the requirements. So it's important when you have a corporation to do that. I meet with a lot of people who have an S corporation, and we'll talk about the taxes in a bit. And their accountants told them they didn't have to do any of that because it's a pass-through now. Not true. The state doesn't care what you're taxed as. You still have to do all these things. So make sure that you're complying with them. It becomes very important if there is ever some sort of lawsuit or issue with the shareholder. All right. So with the corporation, this is the first one where you actually do have to file with the state. So you file your articles of organization or certificate of incorporation. Every state calls them something different. If you're filing in Massachusetts, it's $275 to file, and then you have annual filings, which sorry, I have to update this. The annual filings now are $110. And then you have a franchise tax. Pretty much every state you file in is going to have the state filing fee and then a franchise tax for a corporation. And if you don't file, there are going to be late fees, but the biggest reason is put it in the calendar, remind yourself every year. Corporations in Massachusetts have to file by March 15th. Depending on what state you're in, you have different filing deadlines. Put a reminder to yourself to file it. Because if you don't, usually 2 or more years, usually around the 2-year mark, the state will involuntarily dissolve you. And what that means is you're still a company with all the obligations of a company, but with no liability shield. You'll also find as you go through with contracts that every contract has a clause in it that says you're in good standing in your state of incorporation or organization. And if you haven't filed your annual statements on time, you're no longer in good standing. So then you're technically in breach of all of your contracts. And that can be used against you. Not often, but it can be. So you want to make sure that you keep up on those. Especially if you're the director of a corporation. If it isn't filed on time, you're in breach of your fiduciary duties, and that's personal liability for you. So put it in the calendar. Make sure you keep up with those. Then we'll get to talking about the taxes. So with a sole proprietorship and a general partnership, I had mentioned that they're pass-through, which means all profit and loss just goes on the personal returns of the owners. In a corporation, it's not a pass-through. A corporation, because it's its own individual person, gets taxed. So profit and loss are taxed at the corporate level. And that leads to what's referred to as double taxation. So you may have heard that one. And that's because if $1,000 comes into that corporation, the corporation gets taxed on that $1,000. Then if the corporation issues money to you as the shareholder, you get a distribution or a dividend, you're taxed on that money at your level. So that same pool of money just got taxed twice. Something that people do to minimize that tax liability, especially up front, is they take what's called an S election so that they're taxed as an S corporation. An S election is just a 2-page form that you file to say, hey, IRS, I want my corporation taxed under subchapter S. And what that does is it makes the corporation a pass-through. So it gets taxed like, a partnership or a sole proprietorship. Everything just goes in your personal returns. You do still have a tax filing. You have to file a tax return with the IRS, get issued a K-1 that goes on your own personal tax return, but all profit and loss just gets taxed at your level as opposed to the corporate level and then your level. There are some limitations with an S election. You can only have 100 or fewer owners. You can only have one type of shares. Everyone has to be a U.S. citizen or permanent resident. And they all have to be individuals. You can't have a company own an SCorp. I would say definitely have the conversations that might seem a little awkward and ask people about their citizenship status. Because I've seen quite a few corporations accidentally lose their S election because they gave equity to someone without asking and didn't realize that they were just here on a visa. If you lose your S election, you don't get it back for 3 years. And that means you're double taxation that whole time. So losing the S election could result in thousands of dollars paid in taxes instead of going into the owner's pockets. So just make sure that you're asking about those things if you have the S election. There are also some really great perks to the S election if you stay a closely held company. Most people form a corporation because they're looking for investors. They want venture capital and angel, and those investors want a corporate structure. Those investors like that it's not a pass-through because they don't want to pay taxes on their investment, right? They only want to pay taxes when they make money. They don't want to pay taxes on profit of the company. They also like having those fiduciary duties owed to them. And they like that it's a creature of statute and it's very predictable and they know what's going to happen. They know what their rights are. So unless you're looking for angel and venture capital or doing certain things with your retirement plan, you're probably not going to form a corporation. But if you do, you might do the S election at the beginning. Or like I said, there are some things with estate planning that make an S Corp better for retirement planning than another entity type. But failing all that, if you have the corporation for a while and you're able to maintain that S election for a while, when you get to the point where you can pay yourself a reasonable salary plus make distributions on top of that to yourself, the S Corp has some really great tax savings. So, I guess hypothetically, let's say, in 2022, you paid yourself $70,000. And it looks like, in 2023, you might even be able to pay yourself more. But you talk to your accountant, you determine a reasonable salary for what you do is actually $55,000. You can go on payroll, become a W-2 employee of your company, take the salary of 55. That salary is going to be taxed at self-employment tax. Your distributions getting you up to that like 70, 75, 80, and the next year are going to be taxed at ordinary income. So around 15%, about half the tax liability. So it can be a huge, huge savings if you're self-employed as you go through. Your accountant will have to help you figure out what that reasonable salary is. It's not like a published guideline anywhere. It depends on a lot of different factors. But if you have a good accountant, they'll be able to sit with you and figure out when you've hit the point where you should take an S election, because it can be a huge savings. When you are self-employed and you're making money through a corporation, and it's not passive, it's going to be more when we talk about LLCs. Self-employment tax can be around 40%, state and federal combined. And that's a lot. So when you're self-employed, any way that you can save yourself some tax money ends up being really good. All right. Now we'll go to the next one. Does anyone have questions about the corporation before I move on? Okay. All right. So the next entity is the LLC. It's my favorite. I love the LLC because it's incredibly flexible. So an LLC is a separate legal entity, just like a corporation is, separate from you. However, LLCs aren't heavily regulated by statute. The statutes say, basically, we're going to follow the partnership statute law unless you have an operating agreement that says something otherwise. So you can have an operating agreement, which is a private contract between the owners, and that can govern everything with the LLC. If you don't have it, it just goes by the statute. But that's why LLC is called a creature of contract, because you can just invent what you want for this LLC and how it's going to run, which I find to be incredibly great and beneficial for startup companies and small businesses, because it gives you a lot of flexibility. So with a corporation, you own one share, you vote one share. When dividends are made, you get dividends for one share. With an LLC, ownership and control and money are not necessarily tied together. So if you're just going by the statute, they are. But if you have your operating agreement, you can make a change. So you can own 90% of the company, but only get 10% of the money, or only have one vote and other people get the majority vote. The reason that becomes really helpful is that sometimes you have someone who was able to put in the money, but maybe they have a full-time job and they can't really participate. And the other person is doing all the day-to-day work and putting in that time. You might not want the person who put in the money but isn't involved to be making all of the day-to-day decisions and having the largest vote, right? You probably want the person who's actually doing the work to have that. So with an LLC, you have the ability to make those distinctions. What's also really nice is that you can set up the operating agreement to be your default, and then you can have what are called manager and member resolutions to deviate from the default. So say it's okay, we eventually want to own 50-50, get paid 50-50, have 50-50 control. But right now, you need time to transition. You're still doing your day job. I'm the one who's contributing more at the moment. You can say, all right, since we want that to be the ultimate goal, our operating agreement's going to say everything's equal. But in the meantime, we're going to have a manager resolution that says, when distributions of cash are made, they're going to be made to me because I'm actually the one doing the day-to-day work. Or we're going to change the percentages. So it's not 50-50. Maybe it's 70-30. Or when we make decisions, this is how those decisions are going to be made in the meantime. So again, just incredible flexibility to really have the company work for you and be able to evolve with you, which is why I love it. It allows for a lot of creativity. It also doesn't have the same level of formality. So, with the corporation, even if you're the only owner, you have to have that shareholder meeting and, take minutes of the meeting that you had with yourself. And then the board meeting and take minutes of the meeting that you had with yourself, and the waivers of notice and the notice of the meetings and the stock ledger and all these different things you have to do. With the LLC, you don't have any of that. You can have an operating agreement that requires it or not. You file your annual statement every year, you're done. It's really easy. So it also ends up being cheaper overall. The tax returns are cheaper. The accounting's, always cheaper. Bookkeeping is cheaper. The, LLCs in Massachusetts don't have a franchise tax the way corporations do. So it actually ends up being just cheaper and easier overall, as well as having that flexibility. An LLC is a pass-through, so all the profit and loss go on your personal tax return. It is taxed at that self-employment rate, which depends on the person, but usually somewhere between 36 to 40% state and federal combined. You can actually take an S election on the LLC. So when you get to the point where the LLC is making enough money to pay you that salary and make distributions and get you those tax savings, you can take an S election on the LLC. So it's a good thing to know and make sure that you check in with your accountants as you're producing revenue and it's growing, because that could be a good option. But otherwise, it's a pass through. You're only paying taxes once at the one level, and so you're kind of maximizing your tax savings at the beginning. Something an LLC and the corporation have that actually LLC and the SCorp have that a sole proprietorship and partnership don't, are that you get certain deductions. So there's one's qualified business income tax deduction, 20% of the company's profit. So that's after deductions, just profit is not taxed. It's disregarded. So your tax rate, your tax bracket is all determined after that money is just ignored. It's huge, and it's a really great thing for small businesses. So it's another benefit besides the liability protection of having an entity and a pass-through entity like an LLC or an S-corp. LLCs also have limited liabilities for the members. So if the company incurs a debt, it doesn't flow through. It is pretty stable. It's not as stable and permanent as a corporation in that 100% of the LLC has to be owned at all times. So if you don't have any owners, it can't own itself. But otherwise, as long as there's someone there, it's owned by someone, it operates. You can sell the equity, you can take the equity back, you can shift the equity around. It continues. It makes it really easy to sell and transfer, just like shares in a corporation. All right. Okay. So that's actually pretty easy. If you're a single member, it's just a pass through right to your tax return. You don't really have to, file anything. You don't have to have an operating agreement. If you add someone new, I do suggest having an operating agreement, because now there's actually a relationship between two parties that should be governed by something. But that's optional. You don't have to. And it would just get reported on taxes that you now had a new owner, how much they own, and you would change from everything going to your personal tax return to filing what's called basically a partnership return for the LLC, and then being issued a K-1, and that would go on your personal return. So, yeah. Oh, sorry. Okay. The question was, how easy is it to go from being a single member LLC to a multi-member LLC? And so, yep. Oh, yeah. So I was just going to say, something to always be aware of is that bringing someone into your company and giving them equity means basically it's like getting married. That's a long-term relationship, and it's very messy and difficult to get out of most of the time. Hopefully your operating agreement gives you some good mechanisms for that. But definitely, you don't want to give equity out just because, oh, they did some web development for me and I couldn't pay them and I give them equity. You only want to give equity out to someone that is going to stick with you long-term and really contribute to that company. Sorry, so another question? Okay. So the question was, what's the best structure for an individual artist or creative when they're, like a photographer or a dancer, when they're going from doing this as a hobby to doing this professionally? I think an LLC all the way, especially if you're the only owner, if you're not looking for outside investors. Even if you take on some family and friends, that's okay. Very easy to do through an LLC. Very low maintenance, ends up being cheaper overall. And yeah, it gives you all the liability protection that you need, allows you to sign contracts as an LLC, that actually becomes very important later when you're an individual doing business. We'll talk about that in a bit. It's a great structure for that. Okay. Okay, so the next question was an LLC going from a 3-person to a single-member LLC that has some tax issues, and whether or not you have to dissolve the LLC to make that work. The answer is no. You don't have to dissolve the LLC. The LLC, basically what happens is that you, as the single member that's left, become the only owner of the LLC, and you're going to file a final return as a partnership, and from then on, all of the taxes are going to go on your personal return. Yep. So then the question was, do LLCs provide personal liability protection, like protection for your assets? And the answer is yes. So, the LLC is being run correctly. And so we talked about that a little with partnerships and corporation. I'll talk about it again here. It's an entity. It's separate from you. Separate bank accounts, separate books, separate credit cards. If the company has a bill to pay and it doesn't have any money, you don't ever want to pay that bill individually. Put money in the company account, have the company pay the bill. You always want to treat the company as if it was a third party that you're doing business with versus, your baby. And the reason is because that's what maintains that liability protection, separating the company out from yourself. And as long as you've run the company correctly, and you've filed all of your annual statements, yes, it's going to protect your personal assets. The only time they can go after you individually is usually when it's something really drastic, like you fed poisoned food to a bunch of children or nuns or something. Then you're probably not going to be able to escape personal liability. But for the most part, yes, total protection. Yep. And I think had been the question about when you're going from a hobby to pro. Something I want to throw out about taxes that's helpful there is there's a tax law called the hobby loss rule. And that came around, I think it was the 70s. There were a lot of artists who were claiming to be in business, and they were buying canvases and paint and painting and just putting the paintings up in their attic, not ever selling them, but claiming them as business deductions. And the IRS caught wise to that, and they said, no, it's a hobby. It's not a business expense. So you can't deduct it anymore. And that hobby loss rule has expanded. So first it was just, arts, then it expanded to all creative industries, and now it applies to everyone, which is basically if you are showing a loss every year, at some point the IRS is going to cut you off and say, okay, you can only deduct expenses to the extent that you brought in revenue. So if you spent 500 but only made 100, you can only deduct 100. But one of the ways out of that is to show that you are actively engaging in business. So showing that you have an entity that you pay for and maintain, that you have a website that you maintain, that you have an office. So there are ways for your accountant to show the IRS, no, this is a legitimate business that they're building and growing, and having an entity is a big way to do that. So when you're going from an individual and starting to go professional, the LLC can really help you extend your ability to get those deductions. Okay. So going on to the next part, with an LLC, you file a certificate of organization. If you're in Massachusetts, that's $520 to start it and $520 a year. I know it seems expensive. Everyone complains that LLC is really pricey. It's actually one of the cheaper states because you don't have that franchise tax. So with the corporation, it's $275 to start, $110 a year, but you have a franchise tax of a little over $400 a year. So it ends up being more expensive. In your accounting costs are more expensive. Everything's more expensive. With an LLC, it's $520, which hurts, but it's $520 a year, and you don't have the expensive tax return, and you don't have the franchise tax. So overall, LLCs are usually cheaper. All right. I'm just going to talk about social enterprise a little bit, and then we'll get on to some information about contracts. I don't know if anyone out there is planning to be a social enterprise. Right now, I'm just talking about for-profit social enterprise, because nonprofit could be its own 5-hour seminar. Benefit corporations and B Corp certification are the ones that have really caught on, and that are largely available, and that I would suggest. L3C, if anyone out there is interested in L3C and wants to have a conversation, we can arrange that offline. Sadly, it's not has not reached its potential. So usually you're looking at benefit corporation or B Corp certification. Benefit corporation, this all came around because Ben and Jerry's. is, we all know it, is a really socially innovative and responsible company. They were only working with farmers that, made pledges not to use hormones. They were using a lot of second chance workforce, like Greyston Bakery was giving a lot of opportunities to people who'd been in the prison system and giving them jobs and training. They were using things that were organic and sustainable, and kind of everyone knew they were very politically active. And when you bought from their brand, you knew that this is what I'm giving my money to, is an organization that does these things. So when they went to sell, they had two offers, one from a company like theirs that was socially responsible and would continue on with that mission, the other Unilever, which I have to give Unilever a lot of credit. They've really changed a lot about how they run in more recent years, and a lot of it thanks to this acquisition. But at the time, everyone kind of agreed they were the devil. So the board of directors at Ben & Jerry's did not want to sell to them. They wanted to sell the other company, but the other company had offered less money. And the shareholders sued and said, you have to take the higher offer. Your fiduciary duties as board members is to maximize shareholder value. And the court agreed. They said, you're selling the company. There's nothing you can do here. The board of directors made the argument, well, our consumers are going to be, fooled because they're going to keep buying our product thinking we're this company, but we know that Unilever doesn't run its company that way. And they're going to take advantage of our branding and our goodwill and sell people something that they're not actually getting. And we don't think that they're going to use the same production methods we do. We don't think they're going to give chances to the people that we're giving chances to and supporting. And so we think that for the good of the community and all of the vendors that rely on us, we should sell to the other company. And the court said again, no. Your job is to maximize shareholder value. That's your prime directive. And you might have been able to spend more money and have these practices and make less of a profit before, because your argument was that consumers like this and it increases our value proposition and we make more money. But when you're selling, you can't do that. So it ended up with a settlement that came out of it. Unilever agreed to keep on with some of their practices for a limited period of time, which my understanding is they then found out customers do pay money for this. And they kept it. And that's actually led to a lot of really great changes there. But at the time, it caused a big outrage. Everyone was very concerned. And so this nonprofit was born called B Corp. They initially started with a certification, and they got lawyers together from all 50 states and said, hey, how can we craft language that goes into the articles of incorporation of a corporation that allows the board of directors the ability to consider things other than profit? And how do we do that in a way that's not going to violate a standing corporate law that's so incredibly well established by statute? So they came up with some language. Companies started adopting it. They had this certification process through their nonprofit that goes and looks at companies and makes sure that they are actually making their decisions based on things other than just profit. And that led to working with states to pass new legislation to create a new entity type. So now benefit corporation is pretty well established in a variety of states. I mean, Delaware has benefit corporations now. So if you're in Delaware, you have arrived. And the benefit corporation works language into the articles to allow the company to have basically multiple bottom lines. Triple bottom line was very popular for a while. It's now a lot more than three things. But the board of directors can consider other stakeholders. So not just the shareholders and their share value, but their employees, their community, their vendors. And they're allowed to make decisions based on that. But they also have to file a report for their shareholders to see every year to show how they considered that. They have to come up with a method for considering that. So it was important in the law that they not just use that for marketing and then always make the economic choice. They have to show they've actually given due consideration to these other factors and that they're not always just making an economic decision. Certain industries, these are really popular, anything consumer focused, like for children, food companies, fashion. There are certain industries that if you don't have B Corp certification or you aren't a B Corp, vendors don't want to do business with you. It was really big in organic and artisan foods for a very long time. They were kind of first adopters. So if you are creating a company that you want to have a social mission, that you want to be responsible, but you also want to make money. You don't want to be a nonprofit or your business model doesn't fit well into a nonprofit. This is a really great option because the statutes built up around it make it so that your directors do have to consider this. It's difficult to get rid of the benefit corporation distinction. So if your shareholders ever decided, screw this, we want to be just a traditional corporation, they could do that, but it's going to take a 2/3 vote. So depending on how you've structured your company and ownership, you might be able to prevent that from happening. So it really helps you kind of put your value system into the corporation. There is no benefit LLC, but that's because the LLC is that creature of contract. So if you want anything about your LLC to be mission driven, you just put it in your operating agreement or write it into your articles. There's no prohibition about doing this in an LLC. There are no fiduciary duties in an LLC, so you as the members or managers don't have to worry about being sued for making a non-economic decision. So it's kind of built in. Some other options, we had talked about the general partnership, where everyone's liable. There's a limited partnership, so you'd see that a lot. It used to be for lawyers, accountants, medical practices before the LLC existed. And basically what that does is that there's always one general partner, and that general partner is, listed with the state. These are partnerships you actually do have to register with the state. That general partner has unlimited personal liability. But if you're a limited partner, your liability is limited to the value of your equity in that partnership. Yeah. Yeah. Okay. Got another question.
Hey. All right. So we had a question coming in from Sarah that says, I am an artist who has historically claimed revenue on my personal tax return. Sounds like LLC is a good direction to go to limit liability. Is there a certain point from a liability or revenue standpoint you recommend selling up an LLC? When is the right time to create the LLC?
Okay. That is a great question. It really all depends on the business and the risk. Determining when to file an LLC ends up just being a business decision. I mean, ideally, from day one, you have an LLC in place. Anytime there's any sort of potential liability, the LLC is in place. But sometimes you want to wait. You want to see if this is really a thing, get some proof of concept, build up some revenue, and I'd say it's really going to come down to maybe a combination of risk and assets. Is what you're doing something that's risky? If you're in the food business or doing anything involving children, or if you are holding events where people are coming on premises to experience something, or you're going to them and going into their homes, that's all high liability. Pets, anything to do with pets, even higher liability. Have an LLC. If you're doing things like going to festivals or online and selling your art, probably not as much in terms of liability. You might have to worry about copyright infringement, but that's probably your highest risk activity there. Or data privacy through the website, which if you're using an established site like Etsy or some of the others, you don't have to worry about that as much either. I would say for tax savings, for liability, put it in place, sooner as opposed to later. But if you have to wait till later, just really kind of assess what level of risk you're dealing with, and whether or not you're making any plans to, transfer it or sell it or grow it. Those can kind of dictate your choices as well. And I know it was a really roundabout, annoying lawyer, it depends answer, but it really does depend. Okay. Okay. All right. So another one to mention is just professional corporation. You don't have to worry about that unless you're in a licensed profession. So I have to have a professional LLC, lawyers, doctors, architects, all those. All right, we're going to skip this. And since we have 10 minutes, I want to tackle a little about contracts. If you're a small business owner, you're going to end up dealing with contracts. And I know it's not everyone's favorite thing. I'm a nerd. I love contracts. I like reading them. I like critiquing them. I like editing them. I get that that's strange. I do want to say, though, as a business owner, unless you have a huge budget, you can hire someone like me to read and edit and critique all of your contracts. You better start getting used to them, because you don't want to sign things without knowing what they say. You also want to be clear on what they say. You want to know what those obligations are. So many businesses go under because they signed a contract that had bad terms and they just didn't realize. So make sure that you read it. The legalese, I will tell you, is actually just because contracts are meant to be actually plain language if you're looking at them and interpreting them strictly according to their dictionary definitions. It's supposed to be efficient. It's supposed to be precise. So language. Everyone always mentions like, oh, the heretofores. Well, the heretofore is one word that says everything that came before in this agreement, or everything that came before during this period of time, or from the context. So it takes a whole sentence, makes it one word, makes it very clear and precise. So don't be afraid of that language. Get very comfortable with it. So in order for there to be a contract that's enforceable, there has to be an offer and an acceptance. So if you made an offer to someone, hey, I'll pay you X amount to do this, and they came back and said, well, how about I do XYZ instead? Or how about you pay me this much instead? You don't have a binding contract yet. They have to have made an offer, you have to have accepted. You have to intend to create that legal obligation. And most importantly, there has to be consideration. So if you get a contract where it's like, here are all the things I'm doing, but you're not doing anything for me, it's not a contract. Okay. You have to have all the material terms in the agreement. So you have to have price. You have to have like the obligations. You should have timing. If you leave something big out, the other person might be able to claim the contract's not enforceable. Everyone's heard the term standard contract, I'm sure, standard agreement. It's kind of a misnomer. There is no such thing as a standard agreement. What that means is that it is standard for your business. So it is a contract you have drafted and customized for your company, and you're trying to get people to sign it saying like, these are my standard terms. This is how I operate and what I do in terms of contracting. So it's not like, you can go offline and get a random, oh, look, there's a standard template on there and it works for all situations. It doesn't. The fine print, all that boilerplate. I'm negotiating a lease right now, and the property manager, the lease had a clause in it that said that the tenant will pay for 25% of improvements that the landlord makes anywhere on the property. And they're renting one office suite in this really big building. And they're like, no. And the landlord's like, oh, don't worry about it. It's just boilerplate. It doesn't mean anything. Lies. Boilerplate's enforceable. It's very purposeful. It's there for a reason. The reason it's called, the boilerplate is all the stuff that's in there because those things need to be in there for the contracts to be interpreted and to be enforceable. But it's very enforceable. And you want to make sure that those things are there. We don't have time to go through all this because I want to get through a couple of other things. But these are the types of things that you want to see in there. You want to see like a survival clause, a severability clause. You want governing law. You want gender resolution or dispute resolution. Gender resolution too, especially this day and age. It's really important to have clauses like gender and number, and also to draft your contracts leaving gender out of the equation. And the reason those become important is because contracts are strictly interpreted. So if you go into court with a contract and say it is, 2 females engaged in this contract, but the contract said his or he, the court will say, well, you didn't mean either of you. You meant his or he. They will strictly interpret the contract because courts have determined that business people are very sophisticated and will put in the contract exactly what they want in the contract. And that is why you have clauses like the gender and number clause that say, regardless of the gender written in here, it's going to mean either, both, all of the above. So you want to be mindful of that when you're looking at contracts, because when those things are misapplied, it's a problem. You also want to pay attention to it with pronouns because of numbering. So if you say they, you are literally referring to multiple people. In most situations, depending on the grammar. And that's going to cause a problem with enforceability. So having these clauses in here lets the court know, hey, don't strictly apply that. Be a little loose with it. You can also use names or use other sorts of tags to get around that so it never becomes an issue. So it's something to be mindful about in your contracts. You want the contract to be concise. Your goal is to make it non-conversational. So when you want it in plain English, you want it to be something that when someone reads it, there aren't really a lot of interpretations that you can get out of it. When something's conversational, when we're talking right now, you could walk away from that conversation with a totally different interpretation than I did. And so contracts are meant to distill it and have it be incredibly clear so everyone knows exactly what it means. All right. Let's see. You also want to be careful about cross-references and making changes. So what I see a lot is people grab a contract offline, or maybe they get one drafted, and then they decide to go and make a change later on. When you change one part of a contract, it might affect other parts. there might be other parts of that agreement that have language that's similar or that referred, like, in Section 5, and now you've changed Section 5. So make sure if you're making changes to your agreement that you check all those things. Like, you want to know your contract well so that okay, I'm going to go in there, I'm going to make a change, and I know that that's going to affect something else, and I'll change that too. All right. All right, let's see. I want to run through this last